Hi, my presentation is on the Family and Medical Leave Act. My name is Becca Stoddard, and this is for Cornerstone University, April 2018. The Family and Medical Leave Act was passed in 1993 to allow employees to take off time from work to be with their family or for medical reasons. The Family and Medical Leave Act has a lot that goes into it. First off, coverage and application. FMLA requires employers that have 50 or more employees to provide an employee with up to 12 weeks of unpaid leave during any 12-month period. Any of the following reasons qualify for FMLA: to care for a newborn baby within 1 year of birth, to care for an adopted or foster child within 1 year of the time the child is placed, to care for the employee's spouse, child, or parent who has a serious health issue, if the employee suffers from a serious health condition themselves. Also, for any qualifying non-medical emergency arising out of the fact that the employee's spouse, son, daughter, or parent is covered military member on active duty. Just a couple quick facts about how FMLA came to be. In 1985, it was first introduced into the House and was poorly received. FMLA was introduced to Congress 8 times without becoming law. However, the public was supportive. When President Bill Clinton passed the bill in 1993, 79% of the public was supportive, as shown by an NBC News Wall Street Journal report. In 1996, the country was finally all in and supported the act. Now I'm going to go in and talk about a couple court cases that stood out to me. In Ragsdale v. Wolverine Worldwide, this was the Supreme Court's first time it considered the FMLA in Ragsdale versus Wolverine Worldwide, and this happened in 2002. This was to determine the validity of a Department of Labor regulation implementing the FMLA. Wolverine Worldwide gave its employees up to 7 months of unpaid sick leave. Ragsdale was an employee who was diagnosed with Hodgkin's disease. During treatment, she requested and received 30 weeks of unpaid sick leave. Ragsdale was denied additional unpaid leave as Wolverine Worldwide informed her that she used all her time allotted by the company. When Ragsdale failed to return to Wolverine Worldwide, Ragsdale was fired. At this time, there was a regulation that stated if an employer failed to designate an employee's leave as FMLA and failed to notify the employee of this designation, the leave did not count as FMLA. Ragsdale contested that Wolverine Worldwide owed her an additional 12 weeks of leave in addition to the 30 weeks she had already taken. Ragsdale accused Wolverine Worldwide of interfering with her FMLA rights and sought reinstatement, back pay, and other relief. In return, Wolverine Worldwide argued that it already gave Ragsdale a more than generous leave package than even the law required. And the 8th U.S. Circuit Court of Appeals said that the Labor Department regulation with penalties was invalid, and the Supreme Court agreed. The outcome of this case imposes obligations on both the employer and the employee. Employees must give their employer notice of their leave by providing an FMLA qualifying reason for leave. Employees are not, however, required to use the words FMLA when asking for the leave. Employees must also tell their employer if they wish to substitute paid leave for unpaid FMLA. And employees must provide their employers with at least 2 days' notice. Employers initially must give employees notice of their FMLA rights. And once an employee has requested leave, the employer must notify the employee if he or she is eligible for FMLA, designate the employee's leave as FMLA, and tell the employee if paid leave must be substituted for unpaid FMLA. In Walker v. Verizon, Pennsylvania, a 56-year-old female engineer who was a 36-year employee of Verizon worked on the design engineering team. presented proof of FMLA retaliation and age discrimination in her firing to support a $454,000 verdict plus a $165,000 award of interest and attorney fees. And this is what happened. In 2013, she took approximately 2.5 months of FMLA leave and then returned part-time. Her supervisor documented in her mid-year review that year that she had missed work due to an injury and gave her a less than satisfactory rating on her review. In April 2014, she was transferred to another department. In this new role, she received better scores than her coworkers. And in her 2014 review, she received satisfactory ratings. By 2015, Verizon instructed her supervisor and manager to terminate one person. They were asked to rank and rate the team members before determining who to fire. This was supposed to be done based on performance. However, they did not do a formal rate and rank performance. They discussed over the phone, and then the supervisor contrived a rate and rank to justify firing the plaintiff. The plaintiff and another employee, who was 12 years younger, had the two lowest scores on the rate and rank. The other person that was supposed to be fired was subject to a formal performance improvement plan, unlike the plaintiff. The supervisor did not take this into account on the rate and rank, even though it was required. If the supervisor took that into an account, the younger employee would have had the lowest score and been the one fired. After she was terminated, the plaintiff filed suit against Verizon. The case went to trial, and after 5 days, the jury decided in the plaintiff's favor. She was awarded $188,000 in back pay, $256,000 in front pay damages, and $10,000 in pain and suffering. Verizon filed a motion for judgment as a matter of law. They claimed that the jury instructions were not accurate. However, the court disagreed, and the ruling stood. So why is FMLA important, and why is there an ever-changing perception of FMLA? The FMLA Medical Leave Act of 1983 was a major first step in an effort to recognize and support the work of caring for families. Employees can take an extended leave from work and be assured that they still have a job to come back to at the end of their leave. However, when this was created 25 years ago, it was praised as this was a way for working families to gain security in their job if they wanted to expand their families or be there if someone became ill. However, today, due to significant coverage gaps, more than 40% of workers are ineligible for FMLA leave. Many workers who are eligible can't go without pay or are too concerned about the burden it would be to the family. Currently, among U.S. employees, 26% use it to take leave to care for a new child, 31% of it take leave to care for a seriously ill family member, and 52% of employees take leave for their own serious illness. In conclusion, FMLA does entitle the majority of Americans job security, but we still have a long way to go. The United States is the only industrialized nation without paid family leave. So while it's nice that we have this benefit to us, the rest of the world gets paid for their leaves, and we're the only ones that don't. So again, we have a long way to go. Here are my references.